Thank you, and I'll try and move quickly through. I really appreciate the indulgence of everyone who's been here all day, but I think for all of us to be here together talking about efforts to end this genocide, it's really empowering to be here with all of you, so thank you for listening to me now. Back that first week of October 7th, as we heard Israeli officials make genocidal statement after statement after statement, imposing a total siege, cutting off all basic necessities for life in Palestine. As we've heard, not distinguishing between civilians and those who might be directly participating in hostilities, where they said that everyone is a target, that the emphasis is on death rather than accuracy. As these statements were being made, as the death count was rising, especially among children, we heard very similar statements coming out of the senior U.S. administration, the Biden administration. We saw our Secretary of State rush to Israel, offer unconditional support. We saw our Secretary of Defense rush to Israel and open the stockpile. I just heard $20 million. The stockpile is worth $4.4 billion. And this was opened where Israel can come and take whatever weapons without having to get any kind of approval. And of course, this is on top of the billions of dollars of US aid that the United States already gave. We had Joe Biden who said, "We will be here, we will give you what you need," and that includes arms. So as we had statements of genocidal intent, we had statements of support. And so at CCR, what we did in that very first 10 days is we put together those statements, one against each other. And it told a very clear picture already by October 18th, that the United States was failing in its obligation under the Genocide Convention to take all measures within its power to stop what looked to be an unfolding genocide, i.e. the duty to prevent under Article 1 of the Genocide Convention. And we also saw already by October 18th that the United States was running the risk, if not already there, of aiding and abetting a genocide. So we put together a 40-plus page emergency briefing paper with the facts, starting with the impact on the ground in Gaza, putting it in a historical context. So we weren't starting on October 7th, but we were looking at criminality from October 7th. And we sent it to President Biden, Secretary of State Blinken, we sent it to Karim Khan, we sent it to the US ambassador at the UN, who had thus far vetoed a Security Council resolution, and we said, you are on notice. The United States has an obligation, a duty to prevent genocide, do so. And one of the things that we cited was the United States submission in the Ukraine v. Russia case from September 2022, where the Biden administration recognized the erga omnes obligation, the duty on all states to prevent and to punish genocide. So this was not news, that this is a legal obligation on the Biden administration, but we were putting it back to them. What did we see? We saw more arms rushed. We saw a declaration of no red lines, no conditions, promises that whatever you need, we will deliver, including weapons. We saw 2-ton bombs, bunker-busting bombs, sent time and time again, even as we saw the massive craters in Jabalia, as we saw those people forced to leave the north of Gaza for a safe haven bombed. We saw 1.5 million Palestinians displaced in Gaza, and we saw the weapons continue to flow. So seeing that nothing was done, we did what we haven't actually done in the US courts in about 15 years. We filed a case in US federal court involving Israel. We had done this with Raji Sourani back in 2004, 2005 with the El Daraj so-called targeted assassination, in which 15 people were killed in Gaza when a so-called targeted assassination happened. when 15 people were killed, President Bush, George W. Bush, complained about the use of a 1-ton bomb to Sharon, as he should have. The president of France called this out as a crime. 15 people, none of whom should have been killed, 7 of whom were children. In 2002, that had world condemnation. We had a case, we ultimately lost it. Now in Gaza, we had that death count, those bombs falling by the hour, if not the minute, and the world tolerated it. So we filed a complaint on the 13th of November against President Biden, Secretary of State Blinken, and Secretary of Defense Austin with 2 counts, failure in the duty to prevent and complicity in genocide. The plaintiffs in this case, and so we don't have the standing issue, are 2 Palestinian human rights organizations whose operations in Gaza have been made nearly impossible and whose staff have lost family members. That the lead plaintiff is Defense for Children International Palestine, and at the time the complaint was filed, of the 11,000 killed on the 13th of November, 4,500 of them were children. The second plaintiff is El-Haq, the well-known human rights organization. And then we had 3 plaintiffs from Gaza, including Ahmed Abu Ertema, who should be known in this room as one of the founders of the Great March of Return, whose house was bombed and whose child was killed along with other family members. And one of the other Gaza-based plaintiffs is Dr. Omar Najjar, who could speak to what he was seeing in the hospitals already, again, by November 13th. And then we had 5 Palestinian American plaintiffs who did have standing and who have injury in their own right as part of the Palestinian people, because this is a case of genocide. And it is an attack on Palestinians as Palestinians. So we are arguing that in their own right, they are also being targeted for destruction, and also because of their family members who've been displaced and killed in Gaza. The case is not a case for damages. We were seeking a preliminary injunction to stop the flow of weapons, stop the military, diplomatic, economic, and all other forms of support that the Biden administration has been giving to Israel. And we also sought a declaration by the court that the United States was in violation of international law. The injunction was backed up with a motion for a preliminary injunction, which is something that's supposed to happen quickly. And we filed that on November 16th. And I'm grateful he's left, but to Bill Chavez, he put in an expert declaration on November 16th, saying that the United States was in violation of its duty to prevent. Now, it's hard at this point where we have the decisions, the multiple decisions out of the International Court of Justice, and so much discussion on genocide, to appreciate that for a legal scholar to come out on November 16th and say, yes, the US is in breach of its duty to prevent genocide, was something that caused some shockwaves and helped to give credibility to our case, that this wasn't just taking the rhetoric that we were hearing our fellow activists on the streets saying. And I have to say one thing in the United States that we've seen that may be different in Europe. We've seen many of our Jewish legal comrades and Jewish historians really speaking out so strongly in expert declarations, really saying, give effect to never again. It means against everyone. So that preliminary injunction went in. I'm going to move much faster now. And the United States responded with a motion to dismiss. And as was said, the United States government, because we were suing President Biden, we are suing President Biden in his official capacity, along with Secretaries of State Blinken and Austin. This is an official capacity case. The United States, the Department of Justice, is who responded. And they've said that everything that the president is doing is foreign policy, that the courts can't review this. And I think that is, for me, one of the most chilling pieces of this case from a legal standpoint. Obviously, there's the horrific human, which is far more important, but the fact that the Biden administration is saying, in effect, genocide can be part of our foreign policy. Aiding and abetting genocide can be part of our foreign policy. That is chilling, and that is what it's argued. We responded with a reply brief, and here we put in affidavits from our plaintiffs, so El-Haq and DCIP, updated on all of the deaths that had happened from November through the end of December, the displacements, the same for our US-based plaintiffs whose family members now are over 250 people just from our 5 US-based plaintiffs who've been killed in this genocide. And we also had 8 amicus briefs. And we highlighted through these amicus briefs communities who were impacted. So doctors did an amicus brief, journalists did an amicus brief. We had Palestinian Americans speaking about what it was like, what it is like to have their government being the provider of all of the planes, literally all of the planes that are dropping bombs, and the provider of the vast majority of the weapons that are being dropped on their families, on their people, that are destroying their grandmother's house or the university where they did some studying when they were younger. So it's very powerful testimony that went in through these amicus briefs and affidavits. And we also had an affidavit by Josh Paul. He's one of the early State Department officials who resigned. He was someone who worked in the arms section of the State Department, so not normally someone that we would be working so closely with, but he's come forward and explained in detail the way arms transfers happen. So his testimony is very, very important. And we asked to have a hearing before the district court judge on the motion. And because it's a preliminary injunction, you have to have some level of factual finding. So we asked, please, to have a hearing. And in fact, he did. And I have very mixed feelings, I have to say, about the district court judge's decision. Ultimately, I'm very unhappy with it. But what Judge White did on a day in January, which happened to be January 26th, which is the same day that the RCIJ issued its ruling in the South Africa case. We woke up at 4 a.m. before the argument at 9 a.m. to see what the judgment would be, and we immediately put it in as supplemental authority. And when we walked into the courtroom, Judge White spoke about the RCIJ decision. And in the United States, where the International Court of Justice is not given credibility to have a federal district court judge saying, this morning in The Hague, it was found that there's a plausible case of genocide against the Palestinian people. That was the backdrop for the hearing. And so we had legal argument, but then we had 3 hours of testimony. We had Dr. Najjar from a hospital in Gaza testifying in a US courtroom on video link, which you can still find on our case page, and actually you can still find on the court's case page. This is one of the few cases that they've selected for permanent preservation on their website. So Dr. Najjar speaking about what happens every day in the hospitals of Gaza, the death and the horror that he sees. We had Khalid, who's the executive director from DCI Palestine, testify. We had Ahmed Abu Foul from El-Haq speak both individually as someone from Gaza and as a representative of El-Haq. And then our Palestinian American plaintiffs who used words like Nakba, who used words like ethnic cleansing, who spoke about the fact that their families were in Gaza because they had been displaced during the Nakba. And all of this is now part of the permanent record in a US federal court. This is unprecedented in what we have ever seen, and unlike anything I've seen in my 25 years of being a lawyer. So the hearing itself was powerful, and as we had the hearing inside, the streets were filled outside. And literally the streets were shut down in Oakland, California for this hearing. And what the judge ultimately found was that there is a plausible case of genocide. He found all of the testimony credible. We also had a Holocaust and genocide studies expert, testify, and part of his testimony was about the importance of the duty to prevent. That the reason that is in the convention is because we all, including the judge, need to take action now to stop this. So October felt too late, November felt too late, January felt too late, and we ultimately got a decision that said, despite finding all of this is a plausible case of genocide, it's part of the executive's prerogative as foreign policy, how it deals with Israel. So this is why it is a very mixed finding. Again, the conclusion is a terrifying one. So we've appealed that. Appeal briefs went in the spring. Again, we had many amicus briefs, and here the amicus were even more and further reaching. We had former US government officials from the State Department, from the military, from the national security sectors, all weighing in. We had academics in a very large number talking about the political question doctrine and how this doctrine cannot be used to immunize and hold off limits on lawful conduct, especially when we're talking about genocide, the potential destruction of an entire people. We had human rights organizations, over 190 human rights organizations from around the world with PCHR, they're on top of the list, weighing in and asking the court to review this. So we had our appeal hearing on June 10th. One quick note, it's appeal hearing before the Ninth Circuit. It's before 3 judges. 5 days before our appeal hearing, or 1 week before the appeal hearing, you find out who your 3 judges are. We found out on a Monday, and you start researching who are they, what are their decisions, and we found that one of them, Judge Ryan Nelson, had actually traveled to Israel in March. So 3 months after the appeal was lodged in his court, so he knew he could end up being a judge. This was part of a delegation with the World Jewish Congress. Turns out 11 federal judges went, met with the Israeli Defense Forces, the Israeli forces, military, and toured around. So we did something that, again, is not typical. We moved for him to be recused, and in an even more atypical move, he actually recused himself. So that, through that piece of litigation as a sub-piece, it also showed one of the ways that very explicitly this delegation said it's targeting people who can be influential. So showing the many, many ways that the narrative is trying to be set in the United States, including with federal judges. In this case, Judge Nelson did the right thing by recusing himself, and then we had the hearing. I can't say that I'm necessarily hopeful. It was a very, there were a lot of questions, which doesn't necessarily mean one thing or another. And I think there's some discomfort, I hope, with federal courts being really written out of applying the law. The Constitution is clear that the role is for the courts to define and apply the law. That is not an executive function. The law is clear in the United States. We have a domestic criminal statute prohibiting genocide. And we have that thanks to Joe Biden. When he was senator, it was him who moved to get the United States to finally ratify the Genocide Convention in 1988. And it was him who put forward this legislation to criminalize genocide. So again, Joe Biden is very aware of the legal obligations on him. So it's appropriate for the courts to hold the political branches, and especially the executive, to what it has defined as lawful versus unlawful conduct. And my very last point, I would just want to make a link back to the Nicaragua v. Germany case. I think it hasn't been mentioned yet today, but there was a separate opinion in that case by Judge Sarah Cleveland, who is the new US judge. And I would really commend, if you haven't read this decision yet, to look at it, because it's a decision that's looking about, of course, the provision of arms and whether that crosses a line to either violate the duty to prevent or aiding and abetting genocide. And she's very strong in her language about the legal obligations, and she reiterates in the last paragraph that this is an obligation on, quote, all states. So I think, I would hope that the United States federal judges in our appeals court do allow this case to move forward. And I also hope that the judges listen to the US judge at the ICJ, along with all the other judges there who've made it crystal clear that this conduct is unlawful and the US must stop aiding and abetting genocide. Thanks.